Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3072, United States of America versus Khan Mohammed, appellants. Mr. Swanson for the appellant, Mr. Hurst for the appellee.
Morning, counsel.
Good morning,
Mr. Swanson, please proceed when you're ready.
Yes, Your Honor. May it please the court, Reedy Swanson, on behalf of appellant Khan Mohammed. The government proposes to keep Khan Mohammed in jail for the rest of his life based on a terrorism enhancement that is not supported by the law or the facts. The government relies largely on procedural arguments to keep that enhancement in place, but those procedural arguments are, in the end, illusory. And for that reason, we ask this court to reverse the terrorism enhancement in this case for three reasons. First, applying the terrorism enhancement here violates the plain text of a congressional directive. Second, under any standard of proof, the district court's fact findings here cannot survive clear error scrutiny. They make no logical or temporal sense, and they are directly refuted by the record. And third, the district court's flawed fact finding is especially important because it applied the wrong standard of proof to this case. I'd like to start with that first issue, the congressional directive. In 1996, Congress directed the Sentencing Commission to amend the terrorism enhancement so that it only applies to a federal crime of terrorism. And it defined federal crime of terrorism as a specific list of enumerated offenses with an additional motivational element. Applying the terrorism in this case means applying it to an offense that is not a federal crime of terrorism. And there's no dispute about that. And so for that reason, applying the terrorism enhancement here violates the plain text of Congress's directive to the Sentencing Commission.
So I don't know if it follows like the night follows the day in the way that you just described it. And the reason I say that is this, that if you read the provision, section 730, to mean that an adjustment relating to international terrorism only applies to federal crimes of terrorism, that's the adjustment that needs to be made. And the only way that the commission can conform the guidelines so that it only applies to federal crimes of terrorism is that the underlying offense has to be a federal crime of terrorism. Then sure, your argument prevails. But if you read the provision to say, you've got a guideline that relates to international terrorism, what we want you to do is change that guideline so it relates to federal crimes of terrorism. And then you just do what the commission usually does, is you figure out how to do that. But we're just telling you that it's misfocused right now because it's focused on international crimes of terrorism. And what we want you to do is think about federal crimes of terrorism. And if that's the way you read that provision, then it was, I think even you would, well, you could correct me, but I would assume that you would even say that they faithfully adhered to that because they did shift it away from international terrorism to federal crimes of terrorism. They just didn't go all the way to saying only a conviction of a federal crime of terrorism is enough.
That's right, Your Honor. That is what the commission did, but that misreads the text, I think, in two different ways. First, it doesn't really account for the ordinary meaning of the word applies in the context of a legal application, right? Applies means it is used in that context, right? You apply it to something. You know, it comes from the sort of physical act of applying to a specific thing. And when you say that it applies to a federal crime of terrorism, then applying the enhancement to another offense just doesn't comply with the text. And second, you kind of made the argument.
Before you go to the second one, and just make sure you remember it because I want to hear it. But on the first one, if what the Congress is saying is, right now, as I read the provision, it applies to international terrorism. That doesn't seem like a non sequitur to me. That just seems like Congress could just say, when I read the guideline, it's applying to international terrorism. I want you to change it so it doesn't apply to international terrorism. I want you to change it so it applies to federal crimes of terrorism.
Well, now you've cut the word only out, right? So it's not just that it needs to apply to.
I'll get to only in a second, but just putting only aside for now, on the question of applies, which is where you were focused, understandably, it seems to me that it does work to say it's a guideline now that applies to international terrorism, shift it so that it applies to federal crimes of terrorism.
I see what you're saying. So I think what's happening there is you're saying when Congress says the Chapter 3 enhancement, right? So we're taking the Chapter 3 enhancement essentially as a given, and then we're adjusting it in some way in the rest of the sentence.
Right.
And I think there's another couple of reasons why that reading doesn't work either.
Okay.
And the first is when it says the Chapter 3 enhancement, it's referring broadly to the entire enhancement. It's not subdividing, it's not picking and choosing pieces. It says the entire enhancement applies only to a federal crime of terrorism. And the other reason is that relating to clause that comes after it. So when Congress describes the Chapter 3 enhancement relating to international terrorism, the one thing I think the government and I both agree on here is that what Congress was doing was saying take international terrorism out. So it doesn't really make sense to treat the entire phrase, the Chapter 3 enhancement relating to international terrorism, as a given, and then only apply whatever is there to federal crimes of terrorism, right? So what Congress is saying is only applies to federal crime of terrorism. And Your Honor, I would also point you to the legislative history here, which is, I think, unambiguously clear that when Congress said only applies to federal crimes of terrorism, it meant upon conviction of those offenses. That's exactly what the final conference report said. And so, even if you perceived some sort of ambiguity there about whether that the Chapter 3 enhancement language captures all of it or just a piece of it, Your Honor, the legislative history completely dispels that ambiguity, I think.
What's wrong with what the Fourth Circuit said about the legislative history?
Well, Your Honor, frankly, I have looked at it many ways, and I don't understand how it could be expressing a condition that is just sufficient but not necessary, because the legislative history says only upon conviction of an offense. And in the way that legal logic works, only means necessary, not sufficient. And so, the Fourth Circuit says that in one sentence. It says maybe there's an ambiguity there, but Your Honor, I can't understand how it's reading it that way. The Fourth Circuit didn't explain it, and the government didn't explain it in their brief either.
And then what's wrong with what the Fourth Circuit says, put aside legislative history, about the text, where the point is that why only still works for the commission is that otherwise there would be the danger that the amendment would adjust the guidelines so that it applies not only to international terrorism, but also to federal crimes of terrorism.
Well, one thing that's interesting about the Fourth Circuit's opinion is that it doesn't go that far, right? Even the Fourth Circuit can't bring itself to say the plain text here means what the government says. It says, admittedly, the text is ambiguous, and then it applies Chevron. Now, the government hasn't asked this court to apply Chevron, and we don't think you should for that reason. But even in the context of an ambiguity Chevron type analysis, this court has said over and over that legislative history is part of that step one interpretive toolkit that you apply before deference at step two. And so the Fourth Circuit just doesn't account for the fact that even if you think the statute is in some way ambiguous, as it says it is, you should be looking to the legislative history.
But I wasn't, and this is the last question I'll have in a series note. I'm sure my colleagues can chime in if they want to, but I didn't read the Fourth Circuit to be applying Chevron. I thought what the Fourth Circuit, is Chevron cited in the Fourth Circuit?
It doesn't cite Chevron, but it says it's ambiguous, and for that reason, we're going to defer to the commission's reasonable interpretation.
But I thought what the Fourth Circuit was saying was not that this is a provision that's ambiguous and we're allowing the commission's interpretation of the provision to govern. I thought what the Fourth Circuit was saying was, this is a charter to the commission, like lots of charters to the commission, to go forth and develop a guideline. And the guideline, the only guidance we're giving you is the guideline now talks about international terrorism. We want you to reconform the guidelines so that it talks about federal crimes of terrorism. And then you do it in the way that you usually act as a commission. In fact, so much so that we want you to use the procedures that you normally use when you do this kind of thing, as is spelled out in the provision. And when you get that kind of charter, it's natural to ask, did the commission act within the confines of that charter, which is to say, we look to see whether they reasonably exercised that charter. Not that we're doing a Chevron analysis, but we're basically saying that's just a charter to shift the provision so that it doesn't focus on international terrorism. It focuses on federal crimes of terrorism. And you just have to do that in a reasonable way.
Well, even if you think that there's some difference between Chevron deference and how you've just described it, I think it doesn't make a difference here, because the Fourth Circuit's starting point in its analysis is, admittedly, the statutory text is ambiguous. And it only ever, if you read carefully, it only ever says the commission reasonably interpreted it this way. So mechanically, that's the same as a Chevron analysis, even if it doesn't call it a Chevron analysis.
But I think it does affect whether you bring into play legislative history. Because the way you were saying was that a step on a Chevron, you bring into play legislative history. And I guess if you view it as a charter to the commission just to implement our mandate, then it's just whether they reasonably did that. You don't think about legislative history at that point because the commission has just a charter to implement the mandate.
Your Honor, I'm not aware of any precedent that says that the commission has a sort of super power over the interpretation of congressional directives beyond the interpretation power given to all other agencies. And I think that would be sort of an unusual result. And it would be particularly unusual because it would be suggesting that in this situation, the commission could overlook what appears to be extremely clear legislative history in favor of an interpretation that is not the one that Congress adopted. So I think that giving the commission that kind of power to sort of skip over clear legislative history, and we understand it, ambiguous legislative history would not get you to the same result, right? The thing that really matters here is that Congress speaks in unusually clear terms about the fact that what it meant by only applies is upon conviction of an offense that is a federal crime of terrorism.
I want to just ask you, it's a pet peeve of mine, the misuse of only. Only should actually be at the end of, applies to federal crimes of terrorism only. Would that change your position at all?
Applies to federal crimes of terrorism only applies to federal crimes of terrorism. I don't think so, Your Honor, because the key verb applies. I think what Congress is doing is it's modifying the word applies, and our argument is when it says applies, it means uses in that particular context. And so I don't think that in this particular situation, that particular grammatical piece makes a difference to the meaning of the text.
What can I follow that? I hadn't thought about that. It's interesting. What if the provision said so that the Chapter 3 adjustment that applies to international terrorism applies to federal crimes of terrorism only?
Chapter 3. Can you repeat that one more time?
Yeah.
Sorry.
What if Congress says, we want you to amend the sentencing guideline so that the Chapter 3 adjustment that applies to international terrorism applies to federal crimes of terrorism only?
I'm not seeing a distinction there, Your Honor. I think that because the word applies limits the universe of cases in which the enhancement is applicable, the word only is just telling you limited to only that subset. And that I think would be true regardless of whether you put the word only before the word applies or after the word's found.
I guess what it does is if you view the Chapter 3 adjustment right now as applying to international terrorism, then it tells you that applies doesn't itself require a conviction, right? Because the provision right now talks about promoting or intending, or however it's
yes, the 1994 version that Congress directed said involves or intended to promote.
Involves or intended to promote. So we already know that as long as the conduct involves or intends to promote international terrorism, it's enough, even if the conduct itself isn't international terrorism.
And the other thing that interpretation would raise that we haven't talked about yet is the recognition, I think general recognition, including by the Sentencing Commission in its commentary, that federal crime of terrorism is a category that is broader than the crime of international terrorism. And so it sort of is a little bit nonsensical to say, take this offense that in its given form and apply it only to a category of offenses that is broader than
what about
the
the
one
government's point about state law?
About state law?
Yeah.
Well, the government hasn't provided an example of a crime that is a state law crime that would qualify as international terrorism that is not also a federal crime.
It would promote, it just has to promote international terrorism, right? Or
promote international terrorism. Yeah, no, Yes, Your Honor. If you accept the government's theory of what's happening to the involves or intended to promote language, that is true. Yes.
And it does. International terrorism, as I understand it, does encompass state. Isn't state law in the statute somewhere?
International terrorism wasn't previously defined.
Or state law. State law is in the statute somewhere, right? Is that in the government cite a provision that encompasses state law?
That encompasses state law?
Or am I? We can ask the government.
I'm not sure exactly what you're referring to.
Okay. I could be wrong about that.
But either way, it's not a very intuitive way of thinking about what the word only would be doing in that situation. That's the main point that we want to make. And again, it's not consistent with what Congress told us it was doing in clear terms in legislative history.
Let me make sure my colleagues don't have additional questions for you moved up. We'll give you time for rebuttal.
Certainly, no questions on the other issues that we didn't get to.
I don't believe so, and we'll give you time for rebuttal if we get into it. But
absolutely.
Okay.
Thank you very much.
Thank you, Mr. Swanson. I just want to make sure that we have Judge Rogers on and she's able to hear. We know that. Okay.
I've been on from the beginning and before
Thank
that,
you.
and I can hear you and I can hear counsel.
Perfect. Thank you. Thank you, Judge Rogers. Mr. Hurst.
May it please the court, Ben Hurst for the United States. The district court properly applied the Section 3A1.4 terrorism adjustment. First, the district court did not plainly err in failing to find conflict between Section 3A1.4 as the Sentencing Commission promulgated it in the 1996 Anti-Terrorism and Effective Death Act. The best place to start with this question is actually in the 1994 as part of the context of this promulgation. In 1994, Congress instructed the Sentencing Commission to amend the sentencing guidelines to provide an appropriate enhancement for any felony committed within or outside the United States that involves or is intended to promote international terrorism. This instruction, which led to the involves or intended to promote language in the guideline now, has three components. There's the triggering event. The triggering event is the offense, and as it reads now, is an offense that includes relevant conduct under the guidelines definition. There is a predicate that is international, and then there is a relationship between the two, involves or is intended to promote. There's three portions to it. Now, looking at Section 730, in 1996, Congress instructed the Sentencing Commission to amend the sentencing guidelines so that the Chapter 3 adjustment relating to international only applies to federal crimes. The best way to read this is to say, is to look at what is actually being modified by only apply. It's international terrorism. International terrorism is the category of predicate offenses that follows, involves, or is intended to promote. And the work that the only is doing there is to stop the Sentencing Commission from merely adding federal crimes of terrorism to the pre-existing guideline. So imagine that the statute, Section 730, had omitted the term only. It had just said, amend the sentencing guidelines so that the Chapter 3 adjustment relating to international terrorism applies to federal crimes of terrorism. In that case, the Sentencing Commission might reasonably have simply added federal crimes of terrorism to the guideline as it was written. The work it only does there is a changing function. It's excluding international terrorism from the predicate to which the guideline can apply.
So is there something to the fact that the statute uses the word applies when it's talking about federal crimes of terrorism, but it uses relates to when it's talking about international crimes of terrorism? Because it'd be one thing. I mean, I think the way that you're reading it is that what Congress says is you've got a guideline right now that relates to international crimes of terrorism and adjust it so that it relates only to federal crimes of terrorism.
That's a fair reading, Your Honor. I don't think it's in conflict with the position that we're asserting here. I think that what the relating to there is just identifying for the Sentencing Commission what adjustment we're We're talking about the adjustment that relates to international terrorism. That was the title of the.
Well, that would be done also, it said the chapter 3 adjustment that applies to international terrorism. It would also tell you which one. Right?
That's true, although I think that's correct, Your Honor. I think that's probably right. I don't make a great deal of that distinction because neither of those things is amend the sentencing the adjustment that relates to international terrorism so that it only becomes invoked when a defendant is convicted.
Right. I mean, there's definitely clearer language that Congress could have used to accomplish
That's right.
what the challenger says. I mean, there's clear language that Congress could have used to accomplish what you say too. And I guess the question is, you think basically, and I'm not saying this is right or wrong, but you think basically that relating to and applies are effectively the same thing in the statute. That what Congress is saying is, you take this chapter 3 adjustment that involves international terrorism and change it so that it only involves federal crimes of terrorism.
Well, in that case, Your Honor, that would be actually a very different thing because involves is a term that appears in the 1994 Act and also appears in the guidelines. So if it only
That's true. Okay, so
involves, yeah, that would be a different.
Just do relates to, then keep it at relates to. What you're saying is, when it's saying the chapter 3 adjustment relates to international terrorism, change it so that it only relates to federal crimes of terrorism. That's effectively what you think Congress said here.
I'm thinking about that, Your Honor. I'm trying to see if I see any distinction between the relates to. I really think the relating to is using that word. The relating to is just an identifying function there. And applies is doing some kind of changing function. It's really amending the predicate offenses to which the guideline relates by involves or intended to promote the triggering offenses.
Mm-hmm.
And to be clear, that's the approach that was adopted by Hassan when Hassan considered this very same argument, was that what only is doing there is making sure that the Sentencing Commission doesn't just say that the guideline applies when the defendant commits where the offense involves or is intended to promote federal crime of terrorism or international terrorism. So that work is being done there. We think in this case that the approach that's been adopted by all of the courts that have considered this question, all the courts of appeals that have considered this question, they've all said.
Which is how many?
Well, Your Honor, we have one court, the Fourth Circuit, that has really done a lengthy explanation of and refutation of the defendant's arguments here. We have two additional courts that have kind of implicitly reached that conclusion, either over a dissent that adopts the defendant's arguments here, or by rejecting a district court that made that accepted these similar arguments, although admittedly in that case, the court didn't go on at length about its reasoning. But then we have a number of courts that have applied the intended to promote prong, have found that the guideline is applicable in a situation where the defendant wasn't convicted of an offense that qualified as a federal crime of terrorism. So the implication there, even though they weren't addressing the specific question that the defendant is raising here, certainly that goes to the question of plain error. And if whether the district court's failure to notice this sua sponte was a plainly erroneous error that the court should correct.
So under your reading, so I see what you're saying about relating to only doing the work of telling you what it's talking about. So let's suppose the statute says, amend the sentencing guidelines so that the Chapter 3 international terrorism adjustment only applies to federal crimes of terrorism. You think that's basically what it's saying? Because if it says international terrorism adjustment, that's basically the same thing as saying that adjustment that relates to international terrorism, which is to say the international terrorism adjustment.
Yes, Your Honor. And I think any number of these interpretations of what relating to is doing doesn't get you to what defendant needs here, which is a clear and obvious error.
But just on the question of whether there's an error to begin with. So your reading is that take this provision that now encompasses international terrorism and adjust it so that it only encompasses federal crimes of terrorism. You can leave everything else the same because that's exactly what the commission, you have to think that's okay because that's what the commission did.
Right. I think I'm not, it encompasses seems to sweep a little broader than the work that relating to is actually doing there to me. What relating to really seems to be doing is just identifying for the commission, which what guideline are we telling you?
Right, but I'm just talking about not the before, but the after, which is
Okay.
what does it look like with federal crimes of terrorism? And you have to think that what Congress said is you've got a guideline that relates to, applies to, I'll stop, I won't use involves, but encompasses international terrorism. It's the international terrorism thing. And just make it a federal crime of terrorism thing.
That, I think that is fair, Your Honor. I think that's.
So why is it, well, I don't understand why you're resisting. Because
No,
I'm fair, because that's exactly what the commission did, isn't it?
That's right, Your Honor. I think that's correct. I'm not being resistant to the premise. I'm trying to think to myself what difference that would be from what the guideline or from what Section 730 actually says. The thing that is crucial, I think, is that none of those proposals do anything to remove or to suggest that you had to be convicted of that, and which would be a pretty significant change from, I mean, even the defendants does not seem to acknowledge this that I've seen. Even if you remove the intended to promote prong, it still applies when there's no conviction, because it applies to offenses where there was an involved or where the relevant conduct, which is what offense means under the guidelines. And it doesn't actually ever say convicted. And I don't think any of the suggestions that Your Honor is making get the defendant all the way to where he needs to go, to show even that show even an error, much less a plain and obvious error. I see my time has expired. I'm happy to address additional questions the court has.
Okay, we'll let you rest there, Mr. Hurst. Thank you.
Thank you, Your Honor.
Mr. Swanson, we'll give you 2 minutes for rebuttal.
Yes, Your Honor. Thank you very much. Just a couple of small things to respond to. First, my friend referred to a couple of cases from the 6th and 7th circuits. Those didn't really take up the question at all. It's sort of striking the fact that they don't engage with the congressional text at all. Second, I'd like to just address his suggestion that plain error applies here. We think there are a couple of different reasons why that's not true. First, the district court passed on this question at JA 486 to 487. The court squarely holds that it believes the offense or the enhancement applies to an offense that is not an enumerated crime of terrorism, and cites some of these similar out-of-circuit cases that reach that conclusion without engaging with or addressing the congressional directive here. Second, at JA 468 in our memo, we argue Mr. Mohammed's offense of conviction does not constitute a federal crime of terrorism. And then we say, even if it's intended to promote, even if the intended to promote prong applies, it is improper to apply here. And then we go on to explain why. So I think.
But I didn't read either that statement or the district court statement that you pointed to actually engage with whether the guideline is consistent with Section 730.
That specific issue, you're correct, was not. We did not cite the specific provision, but the Supreme Court has said, and you're not limited to the precise arguments you made below. But even if you think plain error applies, we have plain error here because Glover tells us that a plain text error is plain error, and it says even that is true even in the face of some of the headwinds the government tries to churn up here, including a circuit split where there are circuits that have come out on the other side, and including the opinion in Glover looks to legislative history, which is what we're asking.
But does that mean that any time a defendant makes an argument that they should win under the guidelines, that every district court is supposed to know that what they need to do is not just analyze the guideline, but they need to go back and ask whether the guideline is consistent with some statute that no one ever brought to the court's attention, and the argument was never made, that by saying that we should win under the guidelines, we're telling you, look at the guideline, but then you also should know that you should always look at every statute to make sure it's consistent with every statute that could bear on it too.
Your Honor, I don't think that's the right way to think about what plain error review is. In Henderson, the 2013 case where the Supreme Court holds that it's plain error at the time of appeal, not at the time of trial, the Supreme Court says it's not a grading system for judges. The point is just to make sure that the clear law is clearly applied. And so that's the interest that we're advocating here. It's not a matter of whether the court is supposed to go back and realize or a commentary on the district court's performance at all. It's just a matter of making sure that when Congress has spoken clearly, that clear result is applied in a
Right, but the district court has to know that there's something in question. And if nobody ever tells the district court, the reason we think the guidelines improperly applied to me is that it's in conflict with some statute. If every argument is under the terms of the guideline itself, as opposed to saying the guideline actually as framed conflicts with the statute, if that's never presented to the district court, then, and you still would say the plain error standard doesn't apply, even though that particular issue was never brought to the court's attention that the guideline is in conflict with the language of the statute, then it would mean that a district court is expected to make sure every time it applies a guideline that a guideline is not in conflict with the statute, even if the defendant never makes that argument.
I want to respond to a couple of things, I guess. First, the suggestion that the district court would have to do this and go back. I don't think, I mean, as a practical matter, of course, it would be great, but that's not what we're suggesting. It's, again, not a commentary on the district court's performance. The point is just to make sure that the clear text that Congress enacted is what is in fact applied to the case. That's what the Supreme Court says in Henderson. And so,
Right, but I guess,
sorry, go ahead.
but I don't understand. The question is whether the plain error standard applies, right? I think I'm just.
Yeah. Okay. Yes. So yes, the argument you made, I think, is a question about whether the plain error standard applies or not. But once the plain error standard applies, what matters is the plain text that Congress adopted, and not correct. Yeah.
That I agree with. I guess I'm not talking about whether the plain error standard applies, and on whether the plain error standard applies. In order for the plain error standard not to apply here, in other words, in order to reach the conclusion that either the objection was adequately preserved or it never needed to be preserved to begin with, then I think what you'd have to say is that even though the district court was never told there's a problem with this guideline because it conflicts with the language of the statute, that we would expect a district court to undertake that analysis, notwithstanding that the particular bone of contention was never flagged for the district court.
There's one minor caveat to that I would add, which is when the district court reaches out and addresses an issue, whether or not it's briefed. So even if you assume we didn't brief this issue, if you think that the district court reached out at 468, 46 to 47 and addressed this issue anyway, then that would not be the case. Because I think it would be reasonable to expect district courts to reach out when they've chosen to reach out and address an issue to do so thoroughly.
That's true. And then the question is, did they reach this issue? Because if the district court didn't say, the issue I'm reaching is whether it's the language of the guideline is consistent with section 730, which nobody thinks the district court said that, right? And because the district court never quotes 730 or talks about 730.
That's right. Although the only thing I'll add is the district court does purport to construe the guidelines, and the relevant statutory text here is reproduced in commentary number 4 to the guidelines. So it's not like the district court would have had to go back and comb through the public law of EDPA to find this. The text is right there in the guideline commentary that's printed with the guidelines.
I see. Okay.
And the last thing, Your Honor, I would add is we're not asking, there's been a lot of sort of what is this piece of the phrase, this piece of the phrase, this piece of the phrase mean? And our argument is just that the text as a whole is simply read. It says, do not apply the offense to an offense that, only apply the offense to an offense that is a federal crime of terrorism. And doing so here means applying it to an offense that is not a federal crime of terrorism. Okay, thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-5339, Campaign Legal Center Appellants versus Federal Election Commission. Ms. McAllen for the appellants, Mr. Moeller for the appellee.
Good morning, counsel. Ms. McAllen, please proceed when you're ready.
Good morning, Your Honors. May it please the court, Megan McAllen for Appellant Campaign Legal Center. I'd like to reserve 2 minutes of my time for rebuttal. This case involves the Federal Election Commission's dismissal of a complaint alleging that the 2020 Trump campaign and joint fundraising committees unlawfully concealed the true recipients and purposes of upwards of $750 million in campaign spending, a potential amount in violation that would have been the largest in the commission's history. The record showed that the committees had, in essence, funneled payments to staff and vendors through shell entities controlled by senior Trump campaign officials to avoid disclosing what the statute and FEC precedents require, who they were actually paying, how much they were paying them, and what for. Nevertheless, against the advice of its Office of General Counsel, the commission deadlocked 3-3 on whether the committees had violated FECA's disclosure requirements and dismissed the complaint. The only issue presented here is whether the district court was barred from even considering the faulty legal conclusions in the controlling commissioner's statement of reasons, because in it, they purported to invoke the commission's prosecutorial discretion, even though they did so expressly in reliance on merits considerations. The district court's finding in the affirmative that judicial review is precluded by the Crew cases was wrong for at least 2 reasons. First, neither Crew decision justifies the FEC's extreme position here, which would withhold congressionally mandated judicial review, even as to dismissals that purport to invoke discretionary rationales that directly rest on merits judgments. And second, even if they did apply, the Crew decisions conflict with controlling Supreme Court and prior circuit precedent and should not be given effect. The dismissal here is reviewable either way.
Can I ask a hypothetical question? So suppose that the enforcement authority, the way they explain, and we'll just say the controlling commissioners, the way the controlling commissioners explain a decision not to go forward is to say, we've had our budget cut significantly, and we're only going to go forward in cases in which it's clearly correct. The legal challenge is clearly correct. And so this may be a case in which actually we think the better argument is that it's correct. But we don't think it's clearly correct. And so as a matter of enforcement discretion and as a matter of an informed exercise of discretion in terms of how we're going to expend our resources, we're not going to go forward with this case because we just don't view this case to be a slam dunk. Do you think in that situation there would be review, or do you think, and let's suppose they actually cite Heckler versus Cheney, they adopt their rising class expertise, and they say, and therefore in an exercise of Heckler versus Cheney discretion, we opt not to go forward. Where does that case come out in your view?
Well, for starters, we would submit that because the statute and controlling circuit precedent make FECA dismissals reviewable, that the Crew cases were wrongly decided, and that case would be subject to judicial review. And that doesn't answer the
we
question.
can't, well, for our purposes, we're bound by the Crew cases. And so under the Crew cases, where do you think that comes out?
Under the Crew cases, I think that if there were no underlying legal analysis in the hypothetical as you posed it, that would potentially be covered by the rule of new models, depending on whether there were other indications of pretext or, again, a desire to insulate actual legal substantive conclusions from the review that FECA clearly provides. So you think there wouldn't be review in that situation? If that's all the controlling commissioners say is they say, we see the general counsel's argument. We think actually there's something to the general counsel's argument. There's a lot to it, but we're only going to go forward as an exercise of prosecutorial discretion in cases in which the argument is clearly correct. We don't think this rises to that, and therefore we're not going to go forward. You think no review in that situation? Well, I think in that situation, that may be subject to a separate rule under the Crowley line of cases where the commission has completely abdicated its enforcement responsibilities if it's doing that in more than one case. But under the rule of new models, again, in the world where we assume new models was correctly decided and applicable, I think that scenario would likely be covered and not be reviewable. And why is that? Because I thought your argument was that if the exercise of prosecutorial discretion turns on an assessment of the legal correctness of the position, then there is review. But in the hypo I just outlined,
it would turn on an assessment of legal correctness. It's just that the overlay would be, not only does it have to be correct, it has to be clearly correct.
Well, if I'm understanding the hypothetical as you posed it, I think the difference is that it sounds like they are agreeing that the Office of General Counsel's rationale was likely the correct view of the law, and they're making an evidentiary assessment. Whereas here, they were just saying, no, the law doesn't require disclosure.
They're not making an
at all.
evidentiary assessment, they're making a legal assessment, and they're saying,
But the assessment is that the law likely was violated, but they declined to proceed. And that is very different than the scenario here where they're saying the law wasn't violated. This isn't what the law requires. And we're not going to exercise prosecutorial discretion. We're not going to proceed on the basis of prosecutorial discretion because the law wasn't violated. And that's a very different situation from a recognition that the law was violated. And doesn't pose the same concerns as these cases where clearly erroneous legal interpretations are being permitted to escape review by the invocation of prosecutorial discretion at the very end.
and then what if the controlling commissioners say, this is a close case on whether the law is violated. There's some pretty good arguments that it is. There's some pretty good arguments that it isn't. But close cases aren't good enough for me. I have to think that the law is violated.
Now, again, assuming we're in the world again that new models applies, whereas I think that all commission dismissals are reviewable and clearly reviewable under FICA. That scenario would be a closer question, I think. And again, it's not the world we're in, but if there are no underlying legal rationales for the court to assess, then it may not matter whether it's a highly differential standard or the prevention of review entirely under new models, again, because that rule is inconsistent.
But we can expand the hypothesis so that there is a legal analysis. So suppose the controlling commissioners go through an assessment and they do 12 pages and they say, here's the arguments for why there is a violation, but then there's arguments for why there's not a violation too. And they spell that out for the next 6 pages. And then the conclusion is, it's close. And we just don't go forward in close cases. If a challenger thinks, actually, all the arguments for why there's not a violation are just totally wrong. They're just wrong. You said a bunch of stuff, but you're just wrong about those. Do you think there would be review?
Yes, I think in that scenario, there would definitely be review of the underlying substantive legal analysis to ensure that it was not infected with errors of law, as well as the overall application of a standard that itself could be contrary to law at the reason to believe stage, in particular of commission enforcement actions, where it's just a threshold requirement that precedes several other steps in the enforcement process, including the necessity to find probable cause and then eventual enforcement. So this is by law and by statutory design supposed to be a threshold preliminary determination. And that could itself be contrary to law.
And you think then that would also apply in a case in which the controlling commissioners go through analysis and they say, here's all the arguments for why the general counsel is right and there is a violation. There's actually a couple that give me a little bit of pause. I think those are probably outweighed by the arguments that there's a violation, but I only go forward in cases because of our budgetary constraints in which I'm clearly right. And here, I don't think we're clearly right. And so therefore, we're not going to go forward.
Again, in that scenario, I think it would be reviewable because there are substantive conclusions of law for a court to assess and determine if they are indeed consistent with FICA and statute requires.
Even though that's classic prosecutorial discretion, is that it seems almost inevitable that when an enforcement authority is deciding whether to go forward, they think about the legal merits in some measure to decide whether this is a case worth bringing. Because that's core prosecutorial discretion. Is this a case worth bringing?
It may be a core prosecutorial discretion rationale under Heckler, but again, we're in a world where FICA has expressly rebutted the presumption in Heckler that non-enforcement decisions are unreviewable. So we are in the position, assuming we're applying new models, of trying to parse agency determinations, non-enforcement determinations in action, which, as the Supreme Court found in Aikens, is clearly reviewable agency action. for potentially unreviewable reasons. And I think that that needs to be construed consistent with insofar as we're preserving new models with the statute and with controlling circuit precedent, which makes clear that all FEC non-enforcement dismissals are subject to review.
So since we're in the world of new models, in new models on page 885, the court says, the statement expresses discretionary considerations at the heart of Cheney's holding, such as concerns about resource allocation, and then has a citation of Cheney and a parenthetical that includes the quote in describing what counts as prosecutorial discretion, whether the agency is likely to succeed if it acts. And it seems like concerns about resource allocation and whether the agency is likely to succeed if it acts almost necessarily in the mine run of cases take into account some assessment of the legal merits or demerits of the position or how strong the merits are. But do you think as long as that seeps in to some extent, the strength of the merits, that there's review because of the way FECA works, notwithstanding what we said in new models?
Yeah, I think there has to be review available because that is what the statute requires, and that's what this court's precedents and the Supreme Court's decision in Akins requires. And
what about the footnote 4 that says it's the nature of the decision not to prosecute that matters, not whether legal interpretation underlay the decision?
Well, I think if you look at other language in the panel majority opinion of new models, they make clear that they're interpreting the exercise of discretion at issue there as distinct, quote unquote. They had two distinct bases for declining to move forward with the Cruz complaint. And then if you look at the actual substance of their invocation of prosecutorial discretion in that case, they rested it on considerations that would have been equally applicable, irrespective of whether they thought the law had or hadn't been violated or there was reason to believe. They based it on the defunct nature of the organization and the difficulty the commission might have in proceeding with any kind of enforcement action against it for that reason. It wouldn't matter that they had already concluded in admittedly a very lengthy legal analysis before that, that the law was not violated or there was no reason to believe it was. I think the difficulty that we're in is the fault of the new models and Commission on Hope decisions taking a wrong turn from the circuit's precedents and now trying to perform this enterprise of separating out unreviewable reasons from what is clearly a reviewable action puts courts in a difficult position, as the district court below recognized. But the way to correct that would be to steer the ship to the right course and ensure that the crew decisions are no longer contributing to the inconsistency and disharmony in the circuit's precedents. In other words, to apply Sierra Club to find those decisions were wrongly decided and non-binding on this court.
Yeah, that's a tall order because the panels, it's not as if we would be thinking about things that the panels that decided those cases didn't think about. And it seems like it's asking a lot of a Court of Appeals panel to say that a prior panel actually understood the issue and analyzed it, but just they got it wrong. And therefore you're free to disregard what the prior panel said. Is that the upshot of what you're?
Well, that's the upshot of our alternative argument.
Yeah,
yes.
Yeah, the alternative.
Yes, yes. But we also think that new models is distinguishable. And if it's to be salvaged, it must be read consistently with the rule that we don't assume we know what the agency is going to do on remand if it has two not clearly independent rationales where the justifications that are purportedly discretionary and legal are intertwined. And consistently with this court's other prior circuit precedents, DCCC, Chamber of Commerce, and certainly the Supreme Court's decision in Akins.
Make sure my colleagues don't have questions, additional questions for you, and we'll give you time for rebuttal.
Thank you.
Thank you. Mr. Mueller, we'll hear from the commission now.
May it please the court, Greg Mueller for the Federal Election Commission. The outcome here is controlled by application of new models and Commission on Hope and cases arising.
Mr. Mueller?
Yes.
Is it possible for you to raise the podium? I'm so deaf, but you're tall and
I'll speak louder and try to be closer.
There's a switch to raise the podium.
Yeah, no, the podium is
Is
at.
it already all the way up?
Yeah, it's all the way up.
Oh, okay.
Okay.
Got it.
Cases arising under the Federal Election Campaign Act's judicial review provision fall into two categories. Category one are cases where there's statutory interpretation of FECA and the controlling group of commissioners reaches a conclusion that there is not reason to believe, or in some cases, probable cause to believe there was a violation. The statements issued by controlling groups of commissioners in those types of cases are subject to review under the contrary to law standard. And those are the cases like DCCC and Orlowski and Akins. I call those category one cases. Category two are cases where prosecutorial discretion is invoked by the controlling group of commissioners. These are not subject to review. Commission on Hope, new models, and this case fall into that second category, category two. And the district court properly found that the case for the court today was in that second category where the controlling group invocation of prosecutorial discretion is not reviewable by this court. And
Why is that? Because if you have suppose you have a controlling group of commissioners that issues a statement of reasons, and the statement of reasons says, here's all the reasons that I think this claim would be non-meritorious as a matter of law, that I've got the general counsel's analysis, but I disagree with the general counsel's analysis, and here's all the reasons that I think that the general counsel got it wrong. And I only go forward in cases where I think we're right. In an exercise of prosecutorial discretion under Heckler versus Cheney, I choose not to go forward. Do you think that would be reviewable or no?
it's not, because I think it's an inherent part of the prosecutorial discretion analysis that there is conclusions about an assessment of the underlying matter. And I think what's important
So in
is,
that situation, your answer is it would not be reviewable?
right,
So then what's left? Because if all that happens is the controlling commissioners say, this is wrong as a matter of law, I just think that there's no legal argument here at the end of the day that carries the day. Yeah, I get what the general counsel says. There's something to it, but at the end of the day, I think it doesn't work. If they just stop there, it's reviewable.
correct.
And if they go on from there and they add one sentence that says, as I've explained, the general counsel has an argument about why there's a legally meritorious challenge that could be brought. I disagree with the general counsel's legal analysis. And therefore, in an exercise of my prosecutorial discretion under Heckler versus Cheney, I opt not to go forward because I only go forward in cases where I think I'm right.
Yeah.
Then it's not reviewable.
Yeah, yes, Your Honor, accepting that hypothetical, I think our situation is different because it was kind of a classic.
But just to understand the expanse of your position, then all the controlling commissioners have to do to completely insulate a legal analysis from judicial review is to tack on one sentence that says nothing other than, therefore, in an exercise of my prosecutorial discretion under Heckler versus Cheney, I choose not to go forward.
Your Honor, I think there's a notch of nuance to it beyond that. And I think that it is the controlling group of commissioners have to properly invoke prosecutorial discretion within the meaning of Heckler v. Cheney. And I think that type of analysis is what took place here, a kind of a classic prosecutorial discretion analysis.
So we can get to what took place here, but I just want to make sure I understand the commission's position because it matters. Whatever we say is going to govern a group of cases. And I want to understand the reach of the position. What would be, you said it has to be a legitimate exercise of prosecutorial discretion. What would be illegitimate? Because I think I agree with you that that's a totally legitimate exercise of prosecutorial discretion to say, I think the general counsel's analysis on balance, although there's some force to it, I think the general counsel's analysis on balance turns out to be incorrect. I think the better reading of the statute is that there's no violation here. Therefore, as an exercise of prosecutorial discretion, I choose not to go forward. That seems legitimate to me. I think a responsible prosecutorial official probably has to take into account legal correctness in deciding whether to go forward. and it seems eminently reasonable to decide not to go forward because you think the position ultimately is not legally meritorious. So it would cross your legitimacy criterion, I think it would. But then the question would be, well, what's left? Because at that point, the statute does provide for judicial review of legal correctness in some situations. But if every single time the prosecutor understandably invokes legal correctness in deciding not to go forward as a matter of prosecutorial discretion, then there's nothing left to review ever in any case.
To answer that question, Your Honor, I think what remains is when the commission is construing the statute and reaching a legal conclusion about whether there's reason to believe or not. And that is something that happens very regularly at the commission. It's, there are a lot of, that's what Aikens, DCCC, there's been recent cases on that front. That is the heartland of the AA provision, the judicial review provision. That's what's left. But then there is prosecutorial discretion, and agencies and prosecutors have that, and that's at play here and is not reviewable when it's invoked. And I think there's good reason for that, because the courts are well situated to review the conclusions, the interpretations of FICA and the conclusions and apply a contrary to law standard. But when we're in a situation where they're making decisions as they were here about allocation of resources, relative strength of the evidence, the clarity of the legal standards, and they're evaluating all of that, that's kind of a classic prosecutorial discretion analysis.
Allocation of resources definitely is classic prosecutorial discretion. There's no doubt about it. But suppose that the decision on whether to allocate resources turns entirely on the law. And that seems totally responsible to do too. It seems totally responsible to say, I decide to allocate my resources in righteous cases. And what I define to be a righteous case is one that's right on the law. I decide not to expend my resources in cases in which I think we're wrong under the law. So everything without question, just on the face of the statement of reasons, turns on a legal determination of whether the prosecution would be correct under the law.
To answer that question, and initially I would note that the exercise in this case was rooted on assuming there may be a violation, not wanting to take an outsized portion of the agency's resources. And the district court here said that that was like an independently dispositive ground here and it should be upheld here. But to address the hypothetical, which is the discretionary analysis within the prosecutorial discretion context gets exercised all the time. And the courts aren't really in a position to, follow the prosecutor in making these judgment calls on all of the cases that they confront each and every day. And I think that that's one of the reasons that the discretion exists. It's common for agencies to be making these judgment calls all the time. And when they make a formal interpretation and reach a decision and issue statements of reasons, the controlling group of commissioners then is reviewable under this statute. And that A8 provision is a unique carve out in that respect. But when it's the day-to-day exercise of prosecutorial discretion, that's not reviewable, and that's what Heckler says. And in particular, I think new models really wrestled with that hypothetical pretty directly. And so the new models majority of the panel wrestled with that question and found that that's squarely within the prosecutorial discretion realm, and it's not going to evaluate that, in part because
you think you read new models to say that governs even if the exercise of prosecutorial discretion turns on nothing other than an assessment of the legal merits of the position.
Well, I agree with that, but I do note that it's paired with the Heckler body of law that talks about application of prosecutorial discretion.
Yeah, I guess the question is, do you read new models to say that exercises of prosecutorial discretion are unreviewable? And by exercises of prosecutorial discretion that are unreviewable, we mean to include exercises of prosecutorial discretion that turn on nothing other than an assessment of the legal merits of the position.
Yes, I mean, I don't see that as this case, but
Yeah. And I do want to ask about this case too, but on what you think legal new models covers, you think it covers that situation too?
because prosecutorial discretion is inherently an evaluation of strengths and weaknesses.
Yeah.
So,
To agree with you, I think it.
right. So I don't see that the court, it wants to involve itself in what is a sort of threshold, non-final complete analysis, reaching a final conclusion. I think the prosecutorial discretion analysis begins and ends with an assessment of all of these factors, factoring them in together. I think that there's a balancing of those factors that are kind of inherent in the process. And I think that that is where we are with this.
That all seems exactly right to me on what prosecutorial discretion usually is. It's just that we have a statute that says sometimes the legal merits are reviewable. And if every exercise of prosecutorial discretion is infused with an assessment of the merits, then that could have the capacity to render the judicial review provision nugatory, because you would just say every time there's an assessment of the merits that informs the exercise of prosecutorial discretion.
Yes, and that's why at the outset, I tried to draw the important distinction between the first category of cases where there's a conclusion that can be evaluated under the contrary to law statute or contrary to law standard in the statute. And then there's a second category where these balancing of factors, considerations takes place. That's in the prosecutorial discretion realm. So there are definitely two types of cases that can be reviewed when the controlling group of commissioners puts forth a rationale. One is subject to the contrary to law standard, and the other is an exercise of prosecutorial discretion that's not reviewed. Now, I agree with Ms. McGowan, who just mentioned that there are a couple of, within Heckler, there are a couple of other references to areas that are adjacent to prosecutorial discretion that remain reviewable. If the commission made a determination about its jurisdiction under footnote 4 of Heckler, that remains reviewable. And also, if the commission articulated a statement expressly announcing its intention not to enforce an area of the law, that under Adams v. Richardson would remain reviewable. But the multi-factor discussion of prosecutorial discretion that's at the core of Heckler and was at the core of new models is not reviewable.
Can we look at this case, then the explanation given in this case? The key sentence that you invoked earlier and that the district court understandably focused on is, I think, the sentence that says, this is especially the case because the general counsel's proposed theory is predicated upon factual assumptions about which, oh wait, is that the, no, this is particularly so here, where the size and scope of the proposed investigation could quickly consume an outsized share of the resources available to the commission.
Yes, that was in the statement of reasons and was part of the rationale. Yeah.
And do you read that to mean that even if I thought that this was 100% correct, that there's no doubt that the general counsel's analysis of the law is correct, I still wouldn't go forward because the size and scope of the proposed investigation could consume an outsized share of the resources available to the commission?
The district court found that to be an independently dispositive rationale here. And I think that the statement of reasons itself had a number of factors, but I agree with the district court that that's an independently dispositive basis for addressing the case here. Just the enormity of the investigation, resource considerations. I think they were listing a number of factors that compelled the conclusion, and I think that one does stand alone.
Stands alone, even though the sentence starts out by saying, this is particularly so here. Because it kind of makes it sound like that kind of sounds like the type of sentence you'd throw on as an add-on, as opposed to, by the way, regardless of everything I've said so far, even if you thought everything I've said so far is exactly wrong, still wouldn't go forward because the size and scope of the proposed investigation could quickly assume an outsized share of the resources available to the commission.
I think that particularly is relevant to the prosecutorial discretion. It's such a core consideration under prosecutorial discretion that I think the statement was noting that and emphasizing it in that way. And I do think that especially within the context of the statement itself and the district court's decision, they noted the scope of the matter here and challenges in investigating it. And, both the statement and the district court opinion laid out the complexity of the case. And so when you get to that conclusion, I think it does stand alone in that respect.
As opposed to a circumstance in which the commission could say something like, the controlling commission could say something like, particularly in light of the dubious legal bona fides of the challenge, we won't go forward in a case in which it would occupy outsized resources. Then the merits get seeped into the question of resource allocation. You still think that would be an exercise of prosecutorial discretion that would be unreviewable, but it seems different from one in which there's a criterion that's stated to be totally independent of the merits that would itself be sufficient to persuade the commissioners not to go forward.
Right, and I fully acknowledge that there's certainly prosecutorial discretion analysis that's part of that decision, but what remains reviewable is legal interpretation of FICA reaching a conclusion. That category.
Oh,
Yes, I'll pause. That first category is reviewable, but prosecutorial discretion analysis is different and not reviewable. And I think that's a distinction that's important here.
but you're not saying that in a case in which you have both of those in the statement of reasons, the part of it that's legal would be reviewable.
Right, no.
None of it's reviewable as long as there's a reference to prosecutorial discretion.
Correct, yes, Your Honor.
To make sure my colleagues don't have additional questions for you.
Yes, for
Thank
those
you.
reasons, the district court should be affirmed. Thank you.
Thank you, Mr. Mueller. Ms. McCallum will give you the 2 minutes you asked for rebuttal.
Thank you, appreciate it. I just want to make a couple points. First, on the district court's concerns about the invocation of discretion that supposedly stood apart from pure legal inquiry. I think it's not possible to disentangle even those concerns articulated in the statement of reasons from the underlying merits conclusions on which they quite explicitly rested. First, on the size and scope of the investigation. I mean, that itself rested on the erroneous legal conclusion and imposition of a unduly stringent test for determining whether subvendor reporting was required, under which they would demand proof that an only intended to disguise standard was met. So that would entail a much more onerous investigation and intent, et cetera. And then, of course, they would perceive obstacles to enforcement in a case in which they had already conclusively determined that there was no reason to believe the law was violated. I mean, that would be a fairly simple case to defend against. And then finally, I just want to close by making clear the consequences of the broad legal rule the FEC is articulating and its interpretation of new models to preclude all review, even of intertwined and mutually dependent invocations of discretion with conclusions of law. Under it, the FEC receives automatic and unconditional immunity basically upon a magic words test for citing the right elements of heckler and the right words about prosecutorial discretion resources to insulate what are clearly dispositive merits analyses from all review and the review that FICA explicitly provides. And even though in the deadlock scenario which we're in, these are not precedential at the commission, they're treated as such by many commissioners. And they also constrain the activity of regulated parties. So this is preventing parties from receiving the judicial review that FICA explicitly provides and correcting erroneous interpretations of law in a matter that is extremely important to the health of our democratic function.
Can I just ask you one question, and that's on this key sentence about size and scope? You agree that if this sentence is independent of the merits, if it's a statement that is along the lines of what Mr. Mueller said it is and what the district court appeared to think that it was, which is to say, regardless of the merits, the size and scope of the proposed investigation itself leads me to refrain from wanting to go forward in this case, then under new models, the entire statement of reasons, the entire decision is unreviewable.
Assuming it were entirely independent and it were also entirely clear that it would be independently sufficient, even apart from the merits, then yes, I think that is the rule that purports to require, yeah.
Then what is it about this that leads you to think that the merits necessarily seep in, just when I'm looking at the words? Do you just think it's inherent that always whenever someone talks about an enforcement authority, talks about size and scope and resources, that they're necessarily thinking about merits? Or do you think, unless they specifically say they're not, or do you think there's something specific about the way it's done here that means that the district court and Mr. Mueller's interpretation of this is wrong?
Well, if you look at the clause that begins the concluding part of the statement of reasons, they say for the reasons given above, and there are dependent clauses throughout that sort of refer back to their merits analysis, as noted in the New Models 2 opinion concurring in denial of rehearing en banc. The independence is demonstrated by the lack of a reference back to merits analysis. But when it's unclear, when it's even a little bit unclear, I think that because FICA provides for review and makes these actions reviewable, review must be provided.
Do you think even if the tie goes to FICA, the tie goes to review, in other words, is part of what you're
Yes.
infusing into this? Okay. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-1312 et al. GHD Management LLC, doing business as Windy City Cannabis, doing business as Curaleaf Fleet Street petitioner versus National Labor Relations Board. Mr. Baskin for the petitioner, Mr. Sauter for the respondent.
Good morning, counsel. Mr.
Morning.
Baskin, please proceed when you're ready.
Morning, Maurice Baskin appearing on behalf of Curaleaf Weed Street. I've asked to save time for rebuttal. The company petitioned for review of the National Labor Relations Board's certification of a union election by a one-vote margin. And it was an election plagued by multiple ballot handling irregularities committed by the Chicago region of the board handling the election. This case really on appeal boils down to what is the standard that the board should have used to resolve the outcome of the case. And this court in the National Hot Rod case found the correct standard is clear. That's the quote from the panel in voter ballot handling cases of the board. And the clear standard is if the board itself causes an irregularity and the number of voters possibly disenfranchised to affect the outcome of an election, no certification of the result is appropriate. Now, the court quoted from the same cases that we quoted from in filing the request for review. That's the Garda case and the Wolverine dispatch case, both of which dealt with ballot handling. That is the most sacrosanct part of the election process. That's why the standard is possible disenfranchisement, not the standard that the board applied in this case. This court has repeatedly called the board to account when they announce a policy and then fail to follow it and don't overrule it. They just ignore it. And in a case on very, very similar facts, they ignored the policy. They ignored their own policy. They applied a case called Guardsman, which has nothing to do with ballot handling. It has to do with a pre-election. The employer wanted to do a pre-election speech, and they didn't give them the right time. Totally different scenario, different.
Mr. Baskin, I'm going to take a minute of your time because I want to just set out if my version of what happened is correct. All right, on the side of the voters, and that's Miss Ratton in this case, on March 4th, which was the last day, according to the notice, that if you didn't get a ballot, I gotta take this off, I can hear myself. That if you didn't get a ballot, you had to request one. All right, even the board in its footnote 4 says at the beginning of March, she requested that duplicate ballot. She actually had done more than that. She'd called twice. She hadn't left voice messages. She'd even asked for the cell number of the board agent. She was that intent on getting her vote in. So on the 4th, at least it's clear from my reading of the record that she makes the request. It then takes the board 6 days to mail it. She gets it on the 15th. She has a conversation with the board agent, and she tells that board agent, I'm sending it in today. That's, to me, the most important fact in the whole case, or one of them. Anyway, and so she waits till the next day, or till the 18th. Now, there was no reason for her to think that it would take more than 5 days for it to get there, because it took the ballot 5 days for it to get to her. It takes triple that time, 15 days, 1 day after the election. That's her side of it. Then you look at what the board agent did in this Happy Monday email. And she says, and this is on the 22nd of March, and she says to the parties, we've received ballots from all, at least, that have told me they've sent their ballots in. That is not true with respect to Ms. Rett, who told her on the 15th, or the 16th, I'm sending it in today. She actually sent it in on the 18th. But then she goes on, this board agent, to say, thus, we'll be going forward. In other words, completely leaving one person in this determinative one vote election out of the equation. Then when the vote is taken and it's 11-10, the next day they get Ms. Ratton's ballot. And I believe the company had asked for, after the count, the employer's representative emailed and said, please preserve any late arriving ballot envelopes. Okay, so they get Ms. Ratton, who had sent it 3 weeks before. Now the board agent says, well, I'd like to correct what happened. Then she says the 3 voters' ballots that were received on Friday, March 19th, that at that point, they had then received a ballot from each voter that had contacted her. That is not true either, because Ms. Ratton doesn't get counted until, or doesn't get counted at all, but doesn't get received until the day after the election. And then the board agent goes on to say, I'd like to correct what I said way back, and I don't see how that's relevant. In other words, when she says, well, what I meant was I'd received the ballots of the people who had told me to confirm that I got the ballots. And to me, that is irrelevant. If there's nothing in the record, that board agent would have followed up if she hadn't gotten, which she did not get. She never got the ballot from Ms. Ratton. So the fact that the board agent tries to say, well, what I meant was I got it from everybody who asked me to confirm. That's not relevant unless when she didn't get it, she kept a tally and called and said, Ms. Ratton, I haven't gotten your ballot yet. And then when you look at Hot Rod, that it's only the possibility. Here, there was disenfranchisement of the one voter that made a difference. I'm finished.
Well, you have stated accurately the facts of this case. I can X through my discussion of those facts. And I would just say what you've highlighted in that recitation is the multiple irregularities that for which the board was responsible. The 6-day delay in sending the replacement ballot, National Hot Rod was only a 5-day. So it's worse here. Extending the balloting when it appeared that ballots were delayed and then misrepresenting whatever word you want to use. Statement was false that she made twice, by the way, in her emails to the parties that she said she had not, that all the ballots had been received from people who had contacted her. That was simply false. And her attempt to clarify was not a clarification at all. And frankly, is simply irrelevant. Beyond that, they knew the mails were running slowly and did nothing more to prevent further disenfranchisement. Even a one-day movement would have prevented disenfranchisement here. So the test is, was there a possibility of disenfranchisement caused by the board irregularities? This is a slam dunk case. The only way they avoided that was to ignore their own tests and to say, well, you have to show actual prejudice, although actually we did, to say you had to show beyond a reasonable doubt. We actually have that too, but we should not be there. This case stops with their failure to, and they don't acknowledge Garda Wolverine, let alone National Hot Rod. They just move on and say, well, let's apply this Guardsmart case, which has nothing to do with the facts here.
You don't have to, in order to prevail, you don't need to show, and I don't understand you to be saying that the board representative who sent those communications was acting in any bad faith.
No.
Was intentionally misrepresenting something. Your point is that it just turns out to have given an incorrect impression.
Well,
that everything had been received when in fact there was at least one.
The board said it was confusing. I think it's more than that, maybe more than an incorrect impression, but it is not, it's a flat out statement that something happened that did not happen, and he knew it, she knew it. But it is not necessary to our case. It's an irregularity. That's the standard. And did it have the possible effect of disenfranchising employee and a one vote election, critical one vote? Not that she was the only vote that was not counted, because there was another witness who testified that she had submitted the ballot and was never received. But we're focusing on this particular voter, but mail delays were another aspect of our request for review. And as the dissenting opinion of the board said, taken together, it's an insurmountable case against the board finding and certifying this election. So I'll reserve the rest of my time for rebuttal, unless you have a question.
One further question.
Yes.
Do we know how far away Ms. Ratton lived? This is in Chicago, and it isn't as if, this may not be in the record, it isn't as if that ballot had to travel clear across the country.
No, it did
Can you
not.
say that?
That she was definitely in the Chicago area. I don't have her address. So,
Okay.
but it was definitely within reason for her to think that her ballot would get there on time. And if the board had not delayed in sending the ballot to her, it would have. Almost certainly, which is again not the standard. It's whether it possibly would have. It's not whether it was likely.
In the record, I'm not sure how much this matters, but just to be fair to the record, there's also indications in the record that she could have acted more quickly.
But
and that she actually got that board representative reached out, and she may well have been legitimately very busy, but that there wasn't an effort made to reconnect with the board when they had
right. And of course, the board agent was not allowed to testify, which under normal circumstances would create an adverse inference against such a witness and the party who's not letting the witness testify. So you don't really have the record from the board agent's side, and whose fault is that? It's the board's fault. So, but go back to your question, it's just another irregularity in this whole process that resulted in the disenfranchisement of the dispositive voter. And under the tests that must apply, that your fellow panel has applied in this very, very similar situation, the enforcement action should be denied and the petition should be granted.
Did you try to call the board agent as a witness?
Sorry?
Did you try to call?
Yes, and it's in our brief. It's in each level that we had asked the board agent. It's on the request for review, and they denied contrary to their own precedent. There was really never a solid reason given as to why they wouldn't allow the board agent to testify. We infer it's because the board agent had things to say that would not have helped their case. Thank you.
Thank you, counsel. Mr. Sauter, we'll hear from the board now.
Good morning, Your Honors. Greg Soter for the National Labor Relations Board. May it please the court. I think it's very important to start by laying out the standards for the two objections, in this case, objection 1 and objection 2, because it doesn't stop the way Mr. Baskin says with this possibility of disenfranchisement. When you have a situation where an objection concerns the board's standards and processes, you start with that, but then you go on. You have to prove that there was an actual possibility of disenfranchisement. And to do that, you apply the Lemko test. And the Lemko test asks whether, under an objective standard, the employees were given adequate notice of the election and an opportunity to vote. And, or were they prevented from voting by conduct of one of the parties or by an unfairness in the scheduling or the mechanics of the election? So that is the full standard for objection 1. It does not stop with the possibility.
And
Then
what
for
is fair
I'm
about
sorry.
the mechanic? What is fair about the mechanics of the election when the board agent said, I've got all the ballots back that they told me they'd sent, and knowing in Miss Rath, she didn't have Miss Rath.
Well, now we're getting to the second objection, and that one has its own standard, which is the standard under guardsman. And the question there is whether the agent's conduct raised a reasonable doubt as to the fairness and validity of the election.
I have to say, in reading your brief, I wasn't entirely clear on how we're supposed to know which standard applies in which context.
Well,
I take it that the premise of your brief, let me just ask this question at the outset. The premise of your brief is that the case might be different if the possible disenfranchisement standard applied to objection 2.
No, well,
Well, let me ask you this. You think that the possible disenfranchisement standard, is that, are you calling it Lemko?
yes.
Okay.
Well, it's Garda, but then you apply Lemko after that.
Okay, so the Garda-Lemko complex, that does not apply to objection 2.
No, because objection 2 deals with agent misconduct.
Right, so just to get the premise right. You're saying that the Lemko-Garda framework does not apply to objection 2.
That's right.
So that must mean that if the Lemko-Garda framework did apply to objection 2, the result might have been different. Otherwise, we wouldn't care if it didn't apply. So the premise of your argument has to be, I think, that should the other standard have applied here, the result might have been different. Otherwise, I assume you would have made the argument that it doesn't matter which standard applies, because you didn't make that argument. So
I think it's different, Your Honor. The question is not, the question is what conduct, what is the issue we're dealing with? Is it an irregularity? Something that where it was not misconduct, but it didn't maybe follow the way the rules should have been? In this case, perhaps the agent could have been more diligent in sending the ballot out. Or is it outright misconduct? If it's outright misconduct, then what you're looking at is not just the disenfranchisement of a single employee, but does it put in question the overall fairness of the election?
But how is the election not, it necessarily puts into question the outright fairness of the election if the result might have been different.
Yes, Your Honor. But with Garda Lemko, Your Honor, if you're looking at just the board's, the procedures, whether the board acted correctly or not, then what you focus on is the facts as we know them here. The fact that there were some delays attributable to Mrs. Ratton, there were some delays attributable to the board, but ultimately the buck stops on March 15th when Ms. Ratton has her ballot in hand. At that point, does she have an adequate opportunity to vote? That's the question. And at that point, she has, as Judge Henderson noted, she has 16 days until the final count. So, and it's true her ballot doesn't make it there, but that's not because of the board's doing. The board doesn't control the post office. The board doesn't control when Ms. Ratton sends her ballot. Now, I know where you're going.
But it does control whether there's going to be a delay in the counting. And yes, on March 18th, whenever she sent it, she has had an opportunity to vote. But
Right.
because of the board's irregularity, her vote does not count.
Now, when you're talking about irregularity, you're talking about the lack of postponement, the second one.
I'm talking
Because you said she
about-
had an opportunity to vote on the 15th,
Well, because she mailed it in.
right?
Nobody stopped her from doing that. But then when the board agents said, I've got all the ballots
Okay.
of the people who told me they would send them, thus we can go ahead, we don't need an extension. Knowing that Ms. Bratton, and I'm not talking about misconduct, I'm just talking about incompetence, that knowing that Ms. Bratton told her, I'm sending mine in, and knowing that she didn't have it yet.
Right. So Judge Henderson, I'm
So let
taking,
me ask you, you don't think that's an irregularity?
that's why, Your Honor, that's why the board analyzed that as misconduct by the agent. So clearly it was. But now I'm going to go back.
But not an irregularity.
No, an irregularity would be the delay, for example, that the board agent had in sending
These
it out.
words,
I'm
the
sorry.
fact that one of those is irregularity and not it just, they all start to just come together. It's really
And
hard
that-
to know. I
and
don't
that's-
understand why that's not an irregularity. It seems like it's an irregularity when there's misconduct.
Well, and that's honestly one of the more confusing parts of this case is that it involves the same person, Ms. Ratton, and the same board agent for those two objections. But this court has
And the
long
idea that you'd
recognized.
apply different standards to those two objections just seems odd to me because they're basically talking about the same thing. And at the end of the day, the question in the case is, can we trust this election? Should something have happened differently given the way this came about? And then
Right.
to have this esoteric inquiry where we, put one objection in one box and put another objection in another box, and then we're supposed to have some way of distinguishing one from the other, would have to be a pretty clean way of distinguishing it. And I'm not sure what that is. And let me look, for example, at page 39 of your brief. So this is, I think, part of the effort to explain how we know which box a particular scenario fits into. And this is at the bottom of the page. The numerous cases cited by the company to support its contentions are unveiling. Unlike objection 2, and this is where we get to the distinction between objection 1 and objection 2. Unlike objection 2, none of them analyze objections based on alleged misconduct by a board, regional office, or agent. So that's one box, is alleged misconduct by a board, regional office, or agent. For instance, several of the cases involve regional offices' failure to timely send ballots. If you ask me, does a regional office's failure to timely send ballots connote misconduct by a board regional office? It just seems to me yeah, it does. If a board regional office fails to timely send a ballot, that sounds like alleged misconduct by a board regional office, but apparently not. Apparently those are diametrically different, hermetically sealed things, and they just seem like they're the same thing to me.
I understand your point, Your Honor. There's two things about that. I'm not sure exactly what the board did in those cases and why it applied that standard. But first, this court has long held in Regal Cinemas that it will not question the board's application of a particular standard unless, so long as it's reasonably defensible, okay? That's one. Now, we can argue over the meaning of misconduct or irregularity. What the board found in this place, and I think it's certainly reasonably defensible, is that in one objection, the agent waited several days to send the ballot, but ultimately the ballot got there. In another case, she gave wrong information to the parties. And so that the board found is not just an irregularity, whatever you want to call it, it is outright misconduct. And therefore, it needs to be analyzed under the misconduct standard. And in that case, now turning, as I was saying earlier to Judge Henderson, so we agree, I hope, or I'm not going to presume, that under objection 1, there was no disenfranchisement because Ms. Ratton got her ballot and she still had time to send it back. So we turn to objection 2. Now, it's unquestioned that the board agent gave incorrect information to the parties. The question now is, did giving that incorrect information raise a reasonable doubt as to the unfairness of the election? So let's look at the fact.
First,
Why aren't we asking in this situation whether there's possible disenfranchisement?
because as we've spoken, the board isn't all seeing, Your Honor, right? Obviously, this is a hindsight is 2020 case. If the board had known that this ballot was going to get there one day late, if the board had known that this election was going to be decided by one vote, everything would be different. But
But I thought this category is, apparently this category is about board misconduct, right?
right.
So that's stuff that the board knows. The board,
No, the board doesn't know if an election is going to be decided by one vote, Your Honor.
Nobody knows if it's engaging in misconduct.
Well, in this case, right. So there is misconduct, but that's not where the analysis ends. Does that misconduct put in question the fairness of the election?
But it does.
And if I can continue.
No, you can't, because I want to continue my question.
Go ahead.
Because it seems like it does necessarily call into question the fairness of the election if the election result might have been wrong.
So is an election fair because somebody's ballot didn't get counted because there was
Due to board misconduct.
due to board misconduct?
Right.
Or is it fair or is it unfair because the actions of the board agent showed that there was some kind of, we're not asking if it's unfair to Ms. Ratton, we're asking if it looks unfair to the people who have the most at stake here, the employees. Does it look like the board acted in a way that was intended to privilege one party or tilt the election in favor of one party? And to this day, Your Honor, we don't know how Ms. Ratton would have voted.
Exactly. Yeah, that's the point.
Exactly.
We don't know.
Exactly. And the board agent didn't know at that point either. So they were not trying to tilt the election one way or the other. They were not trying to steer this election in a particular way. In fact, Your Honor, this is the thing.
The decision doesn't turn on that. The decision doesn't turn on an assessment of whether there was bad faith misconduct or something.
No,
It doesn't turn on that at all. If that would have been one thing, it would have been more, I think, sustainable if the board's decision turned on an assessment of the degree of misconduct. It doesn't turn on that. It assumes misconduct. So I think the way we take this case is let's assume it was all intentional. We just assume it was totally bad faith. And the answer that the board gives is it still doesn't matter because it's still speculative as to whether an extension would have been granted.
Well,
That's the upshot, right?
Well, I would add something else to that is that I don't know under your hypothetical how it would be possible for it to be intentional unless this person had it in for Ms. Ratton. But even then, it would only have mattered if this election.
Just to be clear, I don't think it was, but I'm just saying that the way the board analyzes it, it invites the assumption that there was intentional bad faith.
Right.
And it still doesn't matter.
It doesn't matter, Your Honor, not in this case, because the election ultimately. We don't know. Are you saying we should assume bad faith towards Ms. Ratton?
I think the board did. I think the board said.
I disagree. I'm sorry.
I don't think the board assumed it affirmatively in thinking that there was misconduct, a bad faith misconduct. I'm saying the board's analysis says that even if there was, there still wouldn't be relief here because it says we assume misconduct.
Right.
We assume misconduct. What we're going to is whether there's actual prejudice. The reason there wasn't actual prejudice is that we don't know that an extension would have been granted had it been asked for. That would be equally true in a case in which there was affirmative bad faith misconduct. It would still independently rest on the conclusion that regardless of whether there was misconduct, it's speculative as to whether the extension would have been granted if asked for, right?
That is one aspect, but the board makes another finding, Your Honor, before it gets to the prejudice part, which is, did the conduct affect the fairness? Did the conduct affect the fairness of the election? Would somebody looking from the outside think this board agent, by her conduct, did something that affected the way the mechanics of the election, that raises suspicion that there was something else going on?
Mm-hmm.
And in this case, because the board agent at that time didn't know it would be decided by one vote, because we don't know, they didn't know how Ms. Ratton would have voted, that the conclusion of the board is
no, there can't be a doubt as to the fairness of the election because all of those factors were not there. And let me point out as well, the company, neither the company nor, there were at the time Ms. Ratton's ballot was still out there, there were 7 other ballots floating around. Nobody cared about those ballots. Nobody was jumping up and down to get an extension for those ballots. The only reason we are here today, Your Honor, is because Ms. Ratton's ballot arrived a day late. And the evidence that it's not unfair, frankly, is in this courtroom.
Well,
It's because if the election, I'm sorry, Judge Henderson, it's because if the election had come out the other way, I would still be here. But instead of Mr. Baskin, we'd have the union.
Yeah.
So it's not a question of, whether the board's conduct affected the misconduct of the board raised a question as to the board's integrity in the election. It's the question that is not what happened. I'm sorry, Judge Henderson, I cut you off.
Go ahead.
I just have one last thing, and I think we need to call this to a halt. So the hot rod decision, which is our precedent, that's what
Right.
we're bound by, says under the board's standard, and that's, of course, interpreting your client's standard.
The Garda standard, yes?
Under the board standard, it is only necessary for a challenger to an election to establish that it was possible for a board irregularity to have caused a different voting result. Is it your position that if we put in instead misconduct so that it would read, it's only necessary to establish that it was possible for board misconduct to have caused a different voting result?
Oh, I think that would be,
Is that your position? It can't.
it's
That's
the
what you
number,
seem to be arguing, but
it's
anyway,
irregularity as opposed to misconduct, is that what you're saying?
If we just substituted misconduct for irregularity, I mean, that's much worse.
I mean, in that case,
than
the board would have applied a different standard in that case, and I don't know what the result would have been. But hot rod is, just like objection 1 in this case, an issue of an agent delaying a ballot being sent out. And this court applied the first step of the board's test, Garda. It didn't go beyond to Lemko, but that's not necessary. I mean, but otherwise, this court has recognized the Lemko standard. That's in Antelope Valley. This court has also recognized the Guards Mark reasonable doubt standard. That's in Durham schools. So this court knows those standards and how they apply.
Am I understanding it right then that you think that one standard applies in cases of irregularity, another standard applies in cases of misconduct?
That's yes. And I understand we can discuss, there's some semantic difference about what irregularity may mean, whether irregularity, misconduct falls under irregularity or something like that.
Right. I mean, it just seems to me that if that's really what's going on, if these two standards are different, and they have to be different,
Yes.
we're all assuming they're different.
Yes,
Which means by different, I mean that then different results get obtained. That's the only difference that matters,
possible. Yeah.
right? So it's different in a significant way. There has to be some sense, there has to be some coherent framework to understand when one standard applies as opposed to the other one. And if it turns on whether we define something as an irregularity on one hand or misconduct on the other hand, when the words irregularity and misconduct seem relatively coterminous to me, or at least overlapping.
I agree.
Pretty confusing to determine which standard applies in what situation.
Yes, Your Honor. But, and this is getting back to Cron Royale. The question is, did the board's application of the standards in this case, was it reasonably defensible? Is it reasonably defensible for the board to consider that the agent's act of giving false information to the parties was misconduct, outright misconduct, and to consider that the agent's lack of diligence in sending a ballot to Ms. Ratton was not misconduct, was just negligence?
I have one last question, which is on the prejudice prong, because I think I read the prejudice prong to be doing quite a bit of work from the board's perspective.
Yes, absolutely.
So on prejudice, the point you make in your brief, and this is at page 35, is that even if the company would have sought an extension And then even if the union would have agreed to an extension, the regional director didn't have to grant it.
Right.
And might have denied it. And it wouldn't have been an abuse of discretion if the regional director had denied it. And I take the point that the stipulated agreement uses the language of discretion. Of course it does. But in a situation like this, if suppose that we know that there's one ballot that hasn't quite come in yet. And then the company says, hey, I want to get an extension because of that. And then suppose you have a really good faith union and the union says, yeah, I agree with you. Let's get an extension. There's one ballot that's left to come in. You think it would be okay for the acting regional director to say, no, I'm calling it today. I know you all agree. I know there's one more vote that's yet to come in. And for all we know, that vote could be the deciding one, but now I'm calling it today. This is done. We're tallying it today. That could be okay?
Yes, Your Honor, but let me explain. Okay, so it's in the regional director's discretion, right?
Mhm.
The regional director at that point has to balance two important interests. The first interest is giving all employees the opportunity to vote, the broadest, ability to vote. The second is giving finality to the election, getting a result. We're done now, okay? And here's the dilemma facing the regional director in that case. We know there's a ballot that's still out there. By the way, there's 7 other ballots still out there, right? Nobody cares about them. We know there's a ballot still out there.
We know that one's been sent in. With the 7 other ones, we don't know that, right?
Right.
Okay.
We know, based on what Ms. Ratton said, that it was sent in the 16th. She sent it in the 18th, but she told the agent the 16th. Okay, that is now 15 days, roughly, that this ballot has been in the mail somewhere. Is it worth extending the election obviously we don't know it's going to come in the next day, right? Is it worth it? Am I, as regional director, am I abusing my discretion by saying, you know what? I don't know how this election is going to turn out. I don't want employees to have to wait forever. If it doesn't get in 3 days, then are we going to have another extension after that?
You have the union that's representing the employees saying that they're okay with it by hypothesis.
Right.
So you're already taking into account the employee's interest because the union is saying, I'm fine with this. Let's wait a week. Is that okay with you, company? The company says, yeah, let's wait a week and then we'll call it a day. And they both come in and say, we agree. We think we should wait a week. Let's give a week. And in fact, even during that week, maybe the person can just come in and hand deliver a provisional ballot. And then we don't have to wait for the mail.
Yeah.
And then the regional director could still say no.
I think if
Surprising to me.
the union said, we agree, I think it's entirely, I think in my case as regional director, I would say, okay, how long do you want? 3 days? Okay.
Right,
let's
but
do it.
that's what you said.
But again, I think it is not an abuse of discretion for the regional director to say, listen, I want to bring this thing to a close. I think at this point, employees, including Ms. Ratton, whose ballot was mailed 15 days ago, have had enough of a chance to have their voices heard. I want to finish this.
Okay.
Okay?
All right. Thank you, counsel.
Thank you. I appreciate your time, and the board would request that or enforce it. Thank you.
Thank you. Mr. Baskin, we'll give you the 2 minutes you asked for rebuttal.
I'll be brief. What we've heard today is a total lack of a coherent standard. And nothing that was said today by team counsel actually appears in the board's decision. They were presented with the possibility of disenfranchisement standard cited to them, and no mention of it, no mention that we're only treating it for one objection, not the other objection. We presented all 5 objections, and the dissent understood that they should be considered collectively. The board just did not analyze it according to the way we've heard today or in the brief. And it's all post hoc rationalizations for something that is just incoherent and cannot be approved by this court. As opposed to National Hot Rod, that decision is coherent and clear, and most importantly, has already been issued by a panel of this court, which normally other panels would follow. So we ask that you do the same and deny enforcement. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.